Still with us to discuss breakdown is James DeSimone. James, I want to start first, move backwards to talk about implicit bias. Clearly, you can see the emotion, the hurt. This is a tragedy all the way around. There's no good in terms of anything that happened in this case, a clear tragedy. So let's talk about the implicit bias piece and what you may think. Here was part of an excerpt from the op-ed, which is, so yes, Kim Potter is guilty of implicit bias. So am I, so are you. And the question is, what do we do about it in a case where a 26-year veteran police officer with seemingly no cognitive or conscious biases against young black males ends up shooting one? What do we do with her? What do we do with any of us who act poorly, tragically, based upon a subconscious firing of a few hundred neurons that we're not even aware of? All right, James, what's your response to that?
Well, it's extremely interesting, and we use implicit bias in our discrimination cases in the employment context. So I'm certainly no stranger to this. We talk to the jury about it, and it's a theme on closing argument. But the theme is that the implicit bias results in stereotypes, it results in discrimination, it results in harassment at times. It explains behavior, but it doesn't excuse behavior. So in this instance, while I think that Mark is right on in his op-ed piece saying there was an implicit bias going on in terms of Kim Potter's subjective fear that she was probably more fearful because Daunte Wright was African American than a young 20-year-old white man, it doesn't justify criminal behavior if she engaged in that criminal behavior. And the ultimate questions that are being decided by the jury here are still fair game. And I disagree where he says this case shouldn't have been prosecuted. It should have absolutely been prosecuted. She pointed a gun in the chest of a man where no deadly force was warranted, no matter what these police officers are trying to justify now in this trial. You cannot shoot at a fleeing suspect in a vehicle. It causes a higher risk of harm to both that individual and people on the roadway than if you just try to engage him and get him out of the vehicle without utilizing that force. So in this instance, the argument that they had the right to use deadly force, I don't think is justified. An argument that, well, this was really a result of implicit bias, so give her a pass. I don't think we can do that as a society either. We have to have people responsible for their conduct.
In 10 hours, 25 minutes, that's how long the jury has been deliberating as they are determining that very question. Did Kimberly Potter engage in criminal behavior or not? That's the question that they have to answer based on the evidence they've listened to. Can we shift gears a little bit to civil lawsuit? Do you expect that we will see a civil lawsuit in this case against Kimberly Potter?
Oh, I would absolutely expect a civil lawsuit. I mean, civil lawsuits can be based on mere negligence, the failure to use due care in a situation where you have the responsibility and duty to use it. Police officers have a duty not to cause someone unnecessary harm when they come into contact with them. So if somehow it didn't rise to the level of a civil rights violation, where I as a civil rights lawyer would certainly file a case under 42 U.S.C. Section 1983, that her conduct was objectively unreasonable. And in the civil sense, it would be easier to prove that it was objectively unreasonable for her to act the way she did, whether she fired the taser or a firearm into Daunte Wright's chest. Whereas these jury instructions really trouble me for the prosecution in terms of that higher standard where, although it's not an intent to kill crime, it's not murder, they don't have to prove that she intended to kill them. They still have to prove some conscious disregard of the risk.